This video gives you some background information about consumer debt lawsuits. It's just an overview. You can get more information by going to Law Help or finding a Claro program. If you find yourself the defendant in a consumer debt lawsuit, you can expect to meet many new people along the way to getting back to your normal life. A court clerk will process your paperwork, give you important dates, a judge will oversee your case and make a final decision, and along the way Claro can help you make wise choices and provide invaluable information. But what is this whole consumer debt thing anyway? A person has consumer debt when they owe money on loans they have taken out for personal use, like credit cards, car loans, student loans, medical debt, and even gym memberships and cell phones. The person who owes this money is the debtor. The company or person who lent them the money is the creditor. If you have been sued, you do have rights, and you are not alone. Tens of thousands of people were sued for consumer debt in New York City last year. You may improve your chances of success if you know your rights and if you take action. Have I been sued? How do I even know? People find out they have been sued in many ways, including a summons and complaint, a notice from the court, a frozen bank account, a garnishment of their wages, or a bad credit report. The only way to be sued properly is to be given court documents called a summons and complaint. The summons and complaint gives you some important information, like who is suing you and for what amount. This tells you that you are being sued and instructs you to file an answer and appear in court to defend yourself. The answer is how you respond to the summons and complaint. This is where you get to list your legal defenses. You file the answer in court in the clerk's office. If you get a summons and complaint, the most important thing you can do is answer your complaint. If you don't, you could end up with a default judgment, which is bad. It means that you lose automatically because you did not show up to defend the case. If this happens, your wages could be garnished, your bank account frozen, and it can show up on your credit report, preventing you from getting credit, employment, and housing. So take action. If you never got notice of the lawsuit and there is a default judgment, you can still take action by going to court and filing an order to show cause. The Claro program and other legal resources could help you prepare this document. In the courtroom, there will be the judge and other court personnel, including court officers, court clerks, and court attorneys. You are the defendant. The person or company that sued you is the plaintiff. You might not know the plaintiff because your debt could have been bought by another company. The plaintiff usually has a lawyer. He or she is the plaintiff's lawyer. The person who manages and decides the case is the judge. Some courts have an impartial court attorney who works for the judge. The clerk's office is where you file papers in the courthouse. The court clerk will call out cases. There is also a court officer in the courtroom whose job it is to help keep order. A lawsuit has several stages. All of these stages take place on a very strict calendar. The lawsuit starts with plaintiff filing a summons and complaint in the clerk's office. The summons and complaint tells the plaintiff's side of the story. It then gets served on you, and only you. It can't be left in your lobby, left with a minor, or even sent through U.S. mail. The defendant, that's you, then has to file an answer. You get to tell your side of the story in the answer. The answer must be filed in court in the clerk's office within a certain period of time. The number of days you have depends on how you got the summons and complaint. Remember, if you don't make this deadline, you could get a default judgment. When the answer is filed, the clerk of the court will schedule a court date. If you don't show up, you could also end up with a default judgment. Remember, it is important to file your answer on time and that you show up to every court date. At your first court appearance, what happens in court varies from courthouse to courthouse. You will appear before a judge or talk to a court attorney. A court attorney works for the judge and must be fair and impartial. A few things can happen after the first court hearing. Sometimes the judge or plaintiff can ask you for information called discovery. Sometimes the plaintiff will file a motion, which is a request for the judge to consider a request by a party and issue an order. The judge may hold a trial. Consult with Claro or some other legal assistance program before your court date to learn more about what to expect and what your options are. If you get any papers regarding the court case at home, get help from Claro or some other legal resource to understand what they mean and how you can respond. Finally, at the end of the case, the judge will issue a judgment, a decision about who wins or loses, or the parties will settle the case, which is a voluntary agreement between the plaintiff and the defendant to end the lawsuit. A settlement is an agreement between the plaintiff and the defendant about the case. Whether settling is a good idea depends on people's individual circumstances. It's always a good idea to consult with an attorney about the settlement. In some cases, a court attorney works for the judge and might try to help settle a case or review a settlement with you and the plaintiff's lawyer. When thinking about settlement, you want to make sure that you really owe the amount claimed to be owed. The plaintiff has the burden of proof in order to win the case. The plaintiff has to have the right kind of proof about the debt to win a judgment against the defendant. Debt buyers have to present even more proof than the original creditor. They have to show that they bought your particular debt. And remember that your income may be exempt from collection. That means that even if the plaintiff got a judgment from the court, certain amounts are protected and can't be garnished. Exempt income includes things like disability insurance, Social Security, SSI, SSD, pension, or public assistance. TANF. A good guideline is that the first $2,500 of monies in an account is protected if you receive this special kind of exempt income. Otherwise, the first $1,740 is protected. If you have exempt income, make sure you put this in your answer or tell a lawyer. It is very important to answer the complaint. In New York City, the court has a special checkoff answer form for defendants to fill out. Try to talk to a lawyer through a hotline or a clinic, such as Claro, before filing the answer. In your answer, you can let the court know your defenses, which are the reasons why you should either win the lawsuit or have to pay less than the defendant says you owe. Here are some of the most common defenses. Defense 1. Improper service. New York State has strict rules about how a plaintiff has to notify you that you are being sued. If you are not properly served, the lawsuit can be dismissed, at least temporarily. It might be incorrect service if a plaintiff leaves the summons in a different apartment from yours, sends it to an old address where you no longer live, leaves it in your lobby if you have no doorman, or just sends it by mail. If service was improper, you have to make sure you put improper service as the defense in your answer. You should also talk to an attorney through Claro or a hotline because you will need to take certain steps in order for the judge to decide whether the service was improper. Defense 2. Identity theft or mistaken identity. This means that the debt is not yours. This can happen through identity theft or mistaken identity, where you have been confused with someone else. If you are not the right person, make sure you use this defense in your answer. It is usually best not to agree to a settlement if you are the victim of identity theft or mistaken identity. Defense 3. If a debt buyer brought the case, you have the defense of what is called standing. In a debt buyer case, you, the defendant, never entered into a contract with the debt buyer. The debt buyer has to have proof, 1, that you owe the debt, but 2, also that they have the right to collect on that debt. Defense 4. Statute of limitations. The plaintiff has a limited amount of time to file a lawsuit. After this time passes, the case can be dismissed. Speak to Claro or another legal resource to find out if you have this defense. Defense 5. Debt paid, dispute the amount. The debt may have been paid. If so, it's important to raise this defense. Also, you may not agree with the amount that is claimed. You can dispute the amount. These 5 defenses are some of the most common: improper service, identity theft or mistaken identity, lack of standing, statute of limitations, and a paid-off debt. There are other defenses as well. Consult with Claro or other lawyers to determine if you can use other defenses. The most important rule of all is to take action. Even if you are not at the beginning of a lawsuit, if your situation is different, if you are getting debt collection calls, if you already have a default judgment, or receive papers for a motion for summary judgment, or your wages have already been garnished. Get in touch with Claro or another legal resource. The sooner you deal with this, the better your chances of dealing with it for good and getting back to your life.